Hey, what's up, everybody? I want to make this video here. This is a court summons. This is an actual court summons. Uh, I like doing this because this is, real deal situation for someone, and I'm going to tell you exactly how we're going to help them help themselves. I had them send this information over to me for my review, and then I'm going to walk you through it. I won't reveal who it is. Please like these videos because this is real deal information. It helps get the videos out to more people that have these types of issues. So we're going to be dealing with a court summons with this paperwork here. First thing is it says who is suing who, the plaintiff defendant. It's a credit card company, one of the major credit card companies that we all know about. Hold on one second. Sorry about that interruption. So now, this is a well-known debt collection company in the state of California. I'm not going to mention their names, but I've dealt with them several times. And actually, with one particular client that I remember they came after him for a foreclosure, second mortgage on a foreclosure. It was about $22,000. We were able to get that whole debt forgiven. They did send a 1099-C, but he was able to deal with that with filing for hardship with the IRS. But this company is the company that buys all of the credit card debt, or they're also being contracted by certain credit card companies to collect debts in the state of California. So looking down the complaint, it said who's suing who and for what, which was a credit card debt. It has going down the lines here, so please, I'm going to kind of go down the lines because this is how you get to making your answers. You got to just review it. Some of them are very easy to review. Some of them, you got to flip through a lot of pages. And this one here, with the way they do it in California, they have a lot of box checking. Other states just have it all written out. So they had here, it said that it was a civil action not to exceed $10,000, and it notified them of who the plaintiff is. They made them re-notified, and then they had to specify that it's a national bank, because that's a different category for when you're doing these types of lawsuits. All the other boxes didn't need to get checked. Then the other one was, and this is a question. This is a question. It's saying that this pleading includes attachment and exhibits consist of the following on the following pages, and it has the plaintiff's name and it has their national bank. That would be a question that you would say, I do not dispute. And then the next one here, it says, in the rest, there was no checkbox. It says, defendant lives here now. And that's something that is required, and that sometimes they might say resides at this certain address. And that's something that you would just say, I do not dispute when you're writing your answers to their question. The next part, it says, plaintiff prays for judgment for the cost of suit, for such relief as is fair, just, and equitable for the damages of $2,970, and interest, and a specified interest rate that they would put for this date by that date. And so what this is, the part right here is where you start to fight for your rights, because when they specify an amount, their damages, and an interest rate, which I haven't ran across that with a lot of them. This is where you start to do the validation process to them, and you're going to give that information to the court. This is where you say, I do not remember this amount. Really, you probably won't remember the amount because they probably added on fees when it's changed hands from different collectors, if they purchased it or whatever. You will not remember the amount. And that's the God's honest truth. That's, you're being honest when you say that. And so what you do is you say that you do not remember this amount and that you would like to get all of the information pertaining to this debt, original contract, the payments that you've made, all of the charges with your signature or showing some type of signature proving that you authorized the charges on the card, uh, all of the payments that you made, the balances after those payments, interest rate disclosures, all of the disclosures also of when the card would be paid off, because these are new laws that went into effect back, I believe, in 2013 or 2012 when we had after we were kind of coming back out of the financial downturn, that they wanted people, consumers, to be always in the know of when, if they made charges on a credit card, if you pay this payment, it will be paid off by this date. They have to disclose that. They have to disclose the interest rates. They have to disclose if the interest rates change. All of that stuff. So you want them to provide you all of that information so you can review it. So it's not like you're running from a debt. It's not like you're just trying to say, oh, this is not my debt. No, you're trying to get all of the information so you can make an educated decision on how you want to move forward on this lawsuit for this debt. So that's the spot where you would ask for all of that information. And then let's move down. Let's see. These are questions that, some more boxes where it says within the last four, they're just asking that, was this debt within the last 4 years? And they're saying that yes. And they're just, also they have a box saying that the money was lent to the plaintiff, or lent by the plaintiff to the defendant, and then money paid, laid out, or expanded to or for defendant at defendant's special instance and request. They're just, what this is that California makes them go through some, ask the plaintiff more questions to make sure that this is a legitimate lawsuit that they're doing. And then they disclose here at the bottom the amount again, $2,970, and they're saying with the interest rate, and they still have not said the interest rate. So you would just put do not dispute right there. And then they'll have the addresses that you need to send everything back to. You need to send it to the court. You need to send it to the attorney that's handling the case for the individual company. And when you do that, what's going to happen is you're going to usually get information back, and sometimes they'll send it back to you before your court date. If they don't send it by your court date, when you need to go into court and you need to see if the plaintiff attorney is going to have that available to you. You've already notified the judge of what you wanted, so there's no excuse that they didn't get it, and no excuse that the court doesn't know that you want that information. If they don't have that information, then the next thing that they may try to do is to say that they want more time to get that information, which you will have a right to get. Trust me, you just have to trust me on this. They will make them give it to you. If they didn't get it, one thing that you should do, and I always tell people to do this, is that because you had mailed information out to them in the court with plenty of time, as long as it's not like a week or something, but you did it with plenty of time for them to get the information, you can say that you want it to be dismissed on that grounds because you gave them enough time to get that information to you. So you should ask for that. It doesn't hurt to ask for it. Worst thing that could happen is that they say that they're not going to dismiss. They're going to give them more time. If they do have the information, you need to review it. You could ask for more time to review it. That that it's a lot of information, because it could be stacks of information depending on how long you had that account. You need to review it, and you can ask for another court date if you would like, or if the amount is something that you feel that you can negotiate on. Let's just say this one is $2,500, and you know that you had $500, and It's not past the statute of limitations and all of that stuff. All of those boxes are checked off. You can ask for some time to go in the back room with the plaintiff attorney and offer that amount for that debt. You'll be surprised, especially if they've purchased the debt. They probably take that settlement because they don't want to just keep chasing after money if they're not going to get it. They could get a judgment. They maybe not be able to get a judgment against you. They could potentially get a garnishment, or they may not be able to get a garnishment. And so it's, it could go either way. So it's always a negotiation process, and you're gonna have to, kind of work hard to get that settlement. But if you don't have the money, then you need to just ask for more time, and then you can start strategizing on what you could do to be able to move forward. But they just understand that there are always options, and that you should always get all the information before you make a decision. If you like, please like these videos. I'm going to end it there. This is very good information. We're going to be getting this over to this person so they can do their follow-up. But please like the videos. This helps more and more people be able to get this information. We're helping people. There's real life situations. If you need help, you can contact us at thecreditrepairshop.com. If you need your credit reports and scores, you can go to www.scores.com and get your credit reports and scores. Please subscribe to my channel if you haven't subscribed to it. Again, please like the videos and share it and post your comments. I answer all of the comments that come from the videos. Thank you, and until next time.